Welcome back to Watch Your Assets, where we've got your money on our mind. I am your host, Stephanie Bracken, and joining me today is a very special guest. He and his wife are our trusted estate planning partners, and we're so excited to have him on. This is Jim Creenan. So, Jim, thank you so much for joining me today.
Thanks for having me. It's great to be here, and we're really happy to see YTS's success, particularly with its recognition as one of the best places to work. And so we can continue to enjoy working with you and your entire team.
Yeah, absolutely. And the same goes for you guys too. Jim, if you don't mind, just so I don't mess it up, you know your background better than I do. So if you wouldn't mind just sharing a little bit about yourself, a little bit about your background, how you've built the firm that you have, and what's kind of coming for the future.
Yeah, of course. Thanks. We have a good team of attorneys in the Murraysville area. We practice in Allegheny and Westmoreland counties. I'm going on 30 years of being an attorney. My wife Molly practices with me. She's also we went to law school at the same time in the same class, so we have a pretty substantial experience. And for the last 15 years, my practice has been limited to attorney services relating to estate planning, state administration, business formation, and the related areas, including dispute resolution pertaining to business disputes and some estate disputes. So with our team of 8 attorneys, we have the ability to uh, help people plan for their legacies, whether that be personal financial legacy or their business legacy.
Yeah, that's wonderful. And you guys do an incredible job. Every client that we've ever referred to you has been had nothing but good things to say about you guys. So I really want to dive in and kind of pick your brain a little bit about your expertise in the area of estate planning. So I'll just jump right into it. Can you just give an overview of what estate planning entails and why it's important that everybody has an estate plan?
Estate planning can include just the entire process of aligning an individual's desires for what should happen with their wealth and with their family's legacy, but to align that with the beneficiaries that they might have in mind, which oftentimes are their family members. Understanding their assets, how those assets are titled, and ensuring that we can effectively and efficiently transfer wealth from one generation to the next
Yep.
means that estate planning encompasses everything that falls under that very broad description. It could mean annual gifting plans. It could mean developing a simple estate plan with a will, or complicated trust planning, or business succession planning. All of that we would help our clients with to ensure that what they've worked so hard for can get passed on in an appropriate way to individuals that they intend.
Yeah, absolutely. Um, how does and I heard you say will, I heard you say estate plan, of course. How are those things different? What is the difference between your, I guess, entire estate or your estate plan and just having a will?
Right. In Pennsylvania, and where we practice is limited to Pennsylvania because we're licensed attorneys, licensed in the Commonwealth. And estate planning involves where a will-based plan would identify who should receive assets that are titled or that are owned by that individual at the time of their death. Also, a will identify someone who should act as the executor,
Mm.
and the executor's role is to follow the individual's will to ensure that any obligations or debts have been paid, but also to ensure that in the most efficient way possible, beneficiaries can receive what has been intended for them to pass on from their loved one.
Yeah. I heard you say efficiency a couple times. Can you give some examples of efficient transfers of wealth to clients? I mean, I know that's kind of vague, but if there are certain techniques you typically utilize for that efficient estate transfer.
Right, and
Yeah.
efficiency can mean a few different things. One
Mhm.
meaning the time efficiency. How long would it take? How long does it take to ensure that assets are available for loved ones after death? That's one consideration, and depending upon an individual's overall financial plan, we may have different techniques, including beneficiary designations, that will allow for wealth to be available for access shortly after death.
Yeah.
Additionally, we want to look at taxes that would be payable as a result of the individual's death, including the Pennsylvania inheritance tax. Not all states have an inheritance tax, but Pennsylvania does. So any transfers that result from someone's death that go to the next generation or any lineal descendant have a tax of 4.5%.
Mm.
So when we start thinking about what's the best way to pass wealth to the next generation, we want our clients to understand those ideas and understand those concepts so that we can help them decide what makes most sense based upon what they have in their portfolio and how their assets are currently titled.
Yeah. Are there certain techniques in states where inheritance tax comes into play? Are there techniques that we can use to completely avoid inheritance tax, or is that just something that is what it
Yeah,
is and it just
it,
whatever you're getting, you're getting?
right. In a simple way, just to understand how inheritance tax works, that anything that is in your name, either individually or jointly, that you have control over at the time of death, will be taxed
Mm.
or is subject to inheritance tax. Um, Assets that are jointly titled would have a reduced tax based upon the percentage of ownership between one or more individuals. And then also, gifting is a way to pass wealth to the next generation. And as long as it's not made at the final moment, as long as a year has passed after a gift, then that gift would not be subject to inheritance tax in Pennsylvania. So, yeah, the magic is finding what people are comfortable with and finding what an appropriate stage of life where people may not need the income or may not need the assets for security. If they're comfortable giving away, then that's a time to think about different techniques to pass on because we just no one can know when their time of passing will occur, and most of our clients don't want to give away all their assets.
Who should consider having their estate plan reviewed? Anything in that vein.
Okay,
I know that's a little general.
no, I understand because a
Yeah.
lot of our clients don't understand
Mhm.
what will happen if they don't have a simple will. And a simple will for a married couple, say with children, is necessary to ensure that the surviving spouse has access to the family's assets. If a young couple dies without a will and they have children, then Pennsylvania law would require that a portion of the couple's assets not be available to the spouse, but must be held in trust for the surviving children. Now, for a lot of family households, that could really be a nasty surprise when they don't have access to funds and savings accounts and the liquidity that they would need to survive, and particularly survive with the loss sometimes of a primary earner in the
Mhm.
family.
Yeah.
When you lose that, the real insult then is looking at having to tell a surviving spouse that they cannot have full access to those funds and that the
Right.
law would require that to happen. So that's one thing that we want to make sure people understand. Just even having a simple will can be effective. Looking at what stages in life should people have wills, our recommendation is at every stage, and also you need to understand things change over time, right? What you might decide is appropriate in your 20s is much different than when you're in your 80s, and at different phases of life, everyone has a different thought process on providing for children, providing for other family members. Younger people are concerned about providing for parents these days,
Yeah.
right? So parents who might need additional help or assistance is something that our younger clients continue to be concerned about. But our main concern is really all the statistics that come out quite a bit that show roughly only a third of Americans have an updated will. Some are outdated and some are not even effective because they might have been purchased online and
Mm.
not executed correctly, and that can create some additional problems, and that affects the efficiency that we've talked about
Yeah.
before, and that would take more time for the court to allow the will to be accepted.
Okay. What happens if somebody dies without a will or without any kind of estate planning documents in place?
Right. Well, then the law will decide who should receive assets, right? So generally, if someone dies without children and that's not married, then their parents generally will be the two candidates to inherit. In today's blended families, that can create some tension and create some difficulty for parents. And so, one thing that is We also are reminding people if their parents are divorced or if your family is a blended family of any kind, then we want to make sure that there's an opportunity to consider the benefits of having the will.
Yeah.
Yeah.
Yeah, absolutely.
And let me just add one additional
Mhm.
point, if I can,
Yeah.
Stephanie, and that is without a will, then it's going to be up to the court to decide who should serve as an administrator of your estate. Until that happens, anything that's in your name, your bank accounts, other assets and investment accounts, essentially they would be frozen and no one would be able to access them. So when that happens, we see there being additional financial complications that arise from missed payments or inability to meet obligations that otherwise liquidity would have. In this instance, when we have someone without a will, we would also need to understand who would inherit, and that goes back toward will it be the parents or will it be someone else? But who is in control oftentimes is a different battle, and that can be an emotional one fueled by the desire to prove who most loved their family member, and that's a losing battle for everyone because there's no way for the court to correctly pick that, but there oftentimes are choices that are obvious. A surviving parent or a surviving sibling, if the family agrees, are perfect choices, and we help families with through that process quite a bit. Now, not everyone has to agree at the beginning, but we definitely help counsel families to identify what's the best process based upon the absence of a will or even a questionable will, whether we
Mhm.
need to probate that will.
Yeah. So, does the complexity of a person's situation dictate what kind of techniques you might recommend to them? I assume you don't just blanket recommend everything to everyone.
Correct.
So, what are your kind of determining factors of what somebody might need in their estate plan?
Right. And that's an excellent question because we really want to understand the person that's sitting with us. We want to understand their family situation. We want to understand what their interests are, how they have accumulated assets, what's important to them. And bearing in mind that everyone who comes to us has a different set of life experiences, not everyone's going to have the same ideas of what to do with what they uh, bring to the table. And each family is different. The dynamics can be different. And some family members are very self sustaining, others have more needs. And so we want to help people identify what's appropriate and what might be a fair way to address someone's estate.
Mm.
Looking at the complexity, what makes an estate more complex could be the types of wealth, whether the wealth is all in real estate, whether someone's wealth is tied up in a business, or whether there are substantial retirement accounts. All of those require an individualized analysis to say what's the right way to handle that asset and which beneficiary or beneficiaries would be an appropriate person to identify as a potential recipient.
Mhm.
When we look at it that way, some of our clients who have great wealth don't necessarily need a lot of complex planning if they don't have concerns about or if the situation with their family is not as challenging as some might have. But a good example would be a business owner who is looking to maybe retire or put the business into the hands of the next generation. When that occurs, we really want to dig in and find out who's a productive member of the family, um, who can keep the business going,
Mhm.
right? Or is it appropriate to sell the business?
Yeah.
Um, 4 children involved in the family business. You put one person in charge, and you can get 4 different results on a different day. So we wanted to always help our clients look and say, what's the right outcome,
Mhm.
and is it appropriate
Yeah.
to pass shares on of a corporation, a family corporation, into the next hand. And
Mm.
if we do that, and if we help our clients understand that, then we can identify maybe there's some individual additional steps we need to take between planning for a will and just running the normal operations of the company.
Mm.
So a lot of our clients have asked for written succession plans. And so that would mean we've identified how the company is structured now in terms of share ownership, how the company is controlled through its daily operations, which family members are involved, who might be a candidate, and would they be ready to take over today? Oftentimes, the answer to that might be no, but at least we are putting the client in a position where they can say, there's some steps to take either through bringing in maybe an advisory board or bringing in additional mentors or sending someone for some additional education or training or other types of
Mm.
experience could put that family member in a position where they could take over.
Yeah. Wow. That's really insightful. So, whenever I assume you're kind of talking about an executor or a personal representative, someone who would kind of be in charge of administering the estate.
Right.
Do you typically find that that person is one of the deceased's beneficiaries? Do you find that it's a third party? Like, what's kind of the demographic of those people usually?
Yeah, and I think
I know you have this.
generally
Yeah.
generally you have a choice
Yeah.
of between two different types of executors or administrators. That would mean a family member. A family member could be a sibling, but oftentimes the surviving spouse is the first executor that we would choose.
Yeah.
Then the children oftentimes are the next choices. If there's questions or concerns about how things might be administered in the future, or if people are not at the right stage of their life where they could handle the responsibility of administering the estate, then we sometimes might suggest a third party administrator, and those trust companies, often affiliated with banks, are perfect candidates because they have the expertise to administer the estate fairly and to just follow the plan.
Yeah.
They would not be swayed by family emotions. They'll not be swayed by, what happened years ago through family events, and it also avoids questions of, who did mom and dad like best?
Mm, mhm.
I'm the youngest of six, so I know I'm the favorite. But what I always just tell our clients is that this decision doesn't have to follow the age hierarchy.
Yeah.
It's sometimes picking the child who is most familiar or lives closest or can be the best mediator or the person who gets along with the other siblings too.
Yeah.
And so every family is different and every family has a different dynamic that needs to be recognized. And that's one of the art forms that we try to go through is identifying the right people and put them in the right roles within the family estate plan.
Yeah, that's wonderful. I want to go back to, and maybe I should have asked this whenever we were talking before about the fact that only a third of Americans have an estate plan in place. I don't know if you mentioned why that is, or what are some of the reasons why people don't plan for their estate. If you don't mind talking about that a little bit.
No, I think there's several reasons, and I think one of the main reason is immortality.
Mm.
People think they're not going to need it. That's one reason. The second reason is people don't know what the law will actually do if they don't have a will. And I mentioned one of the family scenarios that if a surviving spouse is not going to be happy if they have children because they won't have full access to their funds. What we want to do is help understand, you know, in those scenarios, what are the other reasons people don't have wills to educate our through our some of our talks that we give throughout the community. Want people to understand it's not a hard process.
Hmm.
Estate planning is not difficult. Doing it right takes time, and doing it right has to involve going to the right people and getting the right partners involved, and bringing together the right information. We see there can be mistakes, but why do people really not? Sometimes they just don't know where to go, and they might not know the right lawyer. They might not know someone who can help them, and they don't understand what is the real benefit of planning for your estate.
I have to imagine cost may also come into play a little bit too. They think the administration of their estate or preparing wills is going to be really really expensive, and it's hard to fork up the money if you in your head think it's going to cost you $3,000 to prepare a simple will. Um, that would, I imagine, deter some people from having an estate plan in place.
Yeah,
But
it sure could, and I think that's a very valid point, and, particularly, in the communities we serve, we wanna make sure that we have an appropriate service for our clients, and that would mean also helping, people of all backgrounds. Some people need a simple will. At times, we, certainly, discount things where we need to, but to make sure that people are protected. But people would be surprised at the actual cost of, for most estate plannings through a firm like ours. It can be done on a family budget, and you don't need to be wealthy to have an estate plan or to have excellent estate planning documents as part of your family's protection.
yeah, absolutely.
But the real sometimes the question isn't what does it cost? The question is what's the value that
Mm,
the estate plan provides? And we think explaining the value, explaining just even with a consultation that involves a routine estate plan, we can help people identify savings from inheritance tax depending upon where people are in their stage of life and what they're comfortable with.
yeah.
For instance, making an account joint when we have one client who has already lost a spouse. In that instance, we can help the family have access to the parents' funds, have the family also reduce the inheritance tax that would be due later on. And with effective powers of attorneys and appropriate family controls, those funds will be protected and will, um, and if necessary, through the supervision of the court, would also be available to make sure that funds are available for someone's retirement
Yeah.
and not squandered by family members.
Yeah.
Okay.
You mentioned protection, and I want to talk about life insurance coverage just a little bit. So I have to imagine, and just from what we see as planners, that life insurance can sometimes make up a pretty big part of somebody's estate. So can you talk about some of the advantages and even the disadvantages of life insurance and how that plays into somebody's estate plan?
Of course, and we don't sell life
Yeah.
insurance, so we're not advocating for any particular type of product or company. But what we do understand is that if you're looking to protect a family, and you have a two income household, um, how would the family survive with if they were to lose one of those incomes?
Yeah.
Life insurance is a pretty good way to explore how that benefit and how that income can be made up
Mhm.
appropriately. Additionally, when we have clients that may have sizable estates, they may not have dollars available to pay for taxes that might be due or other expenses that might be due. So, life insurance can provide liquidity to fund the expenses of an estate, including inheritance tax, where someone might own plazas or investment properties for income. And when we have substantial expenses like that coming up, it's a good way to identify a source of where that obligation can be met from. The good thing too is that life insurance is exempt from inheritance tax. So when we have family members also that want to be included in a plan, um, Pennsylvania's inheritance tax for siblings is 12%. For nieces and nephews, it's 15%. So you can imagine someone with a nice estate, $1 million estate, for instance, might have a tax bill of $150,000 if the beneficiaries are all nieces and nephews.
Mm.
What we want to do is help the clients understand: is there a way to offset that, or is there a way to say we're going to divide your estate in a way that your nieces and nephews might get the insurance policies, but your children or your other family members that are taxed at a lower rate will get a different benefit or a different, maybe a portion of an IRA
Mhm.
or a portion of someone's 401(k) plan.
Yeah, that's great. I kind of want to I want to get into politics just the tiniest bit. So, the Tax Cuts and Jobs Act is supposed to theoretically sunset next year, but with Trump getting reelected, I don't anticipate that happening where the lifetime exemption amount may go back to where it was before he got elected. And if that happens, can you talk about what might happen there versus it not sunsetting and continuing to increase at the rate that it's been increasing? I don't know if
Well,
that's a little too political, but it's numbers.
politics aside, it's a
Yes.
complicated subject
Yeah.
for sure, and I might need to come back for a whole new
Yeah.
session just on that. But looking at the history of the federal estate tax, when I was in law school, the federal government's federal estate tax provided an exemption of an individual's first $600,000 of their gross estate.
Wow.
Okay, it in 2017 that number was increased by Congress, and it was at a $5 million level. What we have seen since then is that the number has grown pretty substantially, and in the year 2025, we're at 13,990,000, not 14 million, but
Yeah.
13,990. And so an individual each has that. A spouse has that also. So a household that has roughly $27 million or under does not have to worry about the federal estate tax in 2025 or in 2024 in the past year. If that were to sunset back, then I think we're bringing in a larger population of people
Mhm.
where their gross estate, either through investment holdings, investment, retirement accounts, have grown. So we might see more people if that number rolls back. And I think you're right. The likelihood of that happening, rolling back to the pre-2017 numbers, is not a substantial likelihood, but we're keeping our eye on it. All throughout 2024, all of the groups that we belong to for continuing education have really focused on that. And we were preparing ourselves for all the different techniques that can be used to either reduce or compress estates. Right now, we have all those tools ready for us, and for our existing clients, we want to make sure that we get them on the calendar by the summertime, so that they can ensure we have the right opportunity to help them.
Mhm.
But at the same time, we don't know when Congress will act, right?
Right.
So Congress could agree to just continue to extend those tax cuts all the way for the next 4 years or into the future further. But if they don't, then we really have to be prepared for what will happen to the estate tax in 2026.
Mhm. Can you talk a little bit about what the techniques are that you typically use if you're trying to help somebody avoid that if they're over that lifetime exemption amount, what are some techniques that you use in those cases?
A very good question. And the idea is to for those who are familiar with businesses, we want to get off of your balance sheet
Mm.
so that we can get those numbers below. We also want to look at using a both spouses numbers. And if we look and plan ahead as to what the numbers may be next year without a change, then we want to say, what can we do to bring someone's gross estate below those numbers? Now, if we can't bring it down below those numbers, then we need to make sure that there's funds available to pay a federal estate tax, and that's at a higher rate. But some of the techniques that we might consider would be the use of irrevocable trusts, identification of assets that might be family-owned assets. Business assets are a good example, and where we have agreements that would restrict the transferability of those assets, that oftentimes can at least reduce or minimize the total value of those assets.
Mhm.
Um, there's a few others, but I think those that are really concerning is finding a way to get things off the balance sheet or reduce the number that appears on the balance sheet.
Yeah. Now, along the same lines about trusts, are there certain demographics of people that you typically recommend trusts for? Should everybody have a trust? Is it not appropriate sometimes? What are because I know that trusts get thrown around a lot. I think
Right.
just in the world, we have people ask about trusts all the time if they should put their IRAs into trusts.
Right.
And so, what I guess is your thought on who needs a trust and who doesn't?
Good. Well, not everyone needs a trust.
Yeah.
I'll say that first and foremost. But as in Pennsylvania, there's one thing that the existence of that inheritance tax means that even if you have a trust, assets that are in a revocable living trust will still be taxed, and so you lose some of the privacy that trust would otherwise provide. Um, trusts are much more popular in other states,
Mm,
in community property states, for instance. They're much more popular. Pennsylvania is basically spouse. Each spouse is deemed to own, half of this the property that's owned by them as a couple. What we would see with the trust is a revocable living trust is a way to, it's almost a will substitute. It's a way to plan ahead. And instead of waiting until death, the trust is effective immediately. Changes can be made to a revocable trust, and that's the one great advantage of that. And but once someone passes away, then the trust document will dictate how the trust will be handled and how assets can be handled, not just at death, but even on to the next generation and
mhm.
beyond.
Yeah.
So a trust is a powerful way to help someone uh, use a will planning process, but use the trust as a substitute. That substitute also is effective if someone becomes disabled. If someone develops a medical condition and they cannot act, then assets that are in their trust would be governed by the trust. And the designation of a person called a trustee is just the same as an executor, but it's during their lifetime. And that person would have authority and responsibility to follow the language of the trust.
Mhm.
It's a good way too for to protect assets. If you have a will, you can revoke your will at any time. If a married couple has a will, they each can revoke their will at any time. If there's I mentioned blended families. Sometimes a trust is a way to ensure that assets don't end up in just one of the spouse's families. And
Mhm.
that's one
Mhm.
one thing to think about, where we all try to create a mechanism to allow for uh, a fair distribution of assets after the second spouse dies, so
Yeah.
that each family would receive something. Additionally, a trust can protect the funds from a beneficiary. A lot of beneficiaries that we are experiencing, these are family members that have special needs, or they have addictions of various kinds, and we don't want to put all of these funds in their hands because they might not be able to use them appropriately. They might use them for harm, to harm themselves with drugs or alcohol or other things. So we want to make sure that um, the hard work of our client is protected. A trust is one way to do that, because the beneficiary would need to go to the trustee and make a request for funds. A trust is also a way to sort of manage certain assets, rental properties, or properties that are appropriate for a family member to live in after mom or dad has passed. That's a good mechanism as well.
Mm, mhm.
There's a completely other topic of Medicaid planning that we're not going to approach too much today, but that idea would be that giving a house into a trust, or putting assets into a trust, again, would take those assets away from someone's list of resources that would have to be counted if they were to apply for medical assistance as a prerequisite of receiving payment for nursing care.
Yeah. Now, along the lines of incapacity planning, I guess, um, I've heard it called the big three: a will, your powers of attorney, and your healthcare directives. Can you talk a little bit? We talked about wills a little bit, but can you talk about the other two and how that affects what happens to your medical decisions?
Absolutely. So the two types of powers of attorney that we provide to all of our clients. One is medical, and we have a form that's a combined healthcare power of attorney. That document chooses someone to make decisions in the event that you cannot act.
Mhm.
It provides HIPAA authorization for the release of information, and also the combined element is the living will. The living will is an individual's choices uh, as to receipt of life-sustaining treatment during periods of final illness, when there's no realistic hope of recovery. And in that situation, we often see a family member, spouse, and then children, all considered to be agents of an individual, so that if someone can't make a medical choice, then their family member is available to do that. In a similar way, a durable financial power of attorney will allow someone as a principal to choose an agent, and that agent is able to step in the shoes of the principal to make decisions and take actions for the principal. By doing that, everything from dealing with financial institutions, making investment choices, filing tax returns, or dealing with other government benefits. We have a very comprehensive power of attorney that covers just about anything you can imagine, including digital assets. And that access today, each week, we're seeing more and more issues that are arising as a result of ownership of different types of accounts. There are a lot of creators who have receive compensation from different social media platforms. And as a result of that, we want to make sure that there is a mechanism in place for the agent to be able to access those funds in the event of any disability. Now, we generally draft the power of attorney so it's effective immediately. There's not a need to go to doctor's note to say someone is incapacitated, but the idea is that we want that document to be ready and to be effective immediately in case there is an emergency down the road.
Yeah.
And as long as we help people choose the right people to be agents, we generally have not had any difficulty with people misbehaving. So
Yeah.
it happened one time
Yeah.
about 15 years ago. I had a family member come to me, and their sibling, using a power of attorney, had written checks. And I think 4 or 5 times in 1 year, they replaced the mom's roof. And usually you'd only have to do that about once every 20 years. So we knew there was something wrong
Yeah.
with the sibling. So we were able to get that worked out after going to court. But the idea is picking a responsible family member, not just the closest family member, but someone who can be trusted and who's not going to take advantage of having unlimited access.
Mhm. Yeah. That's gotta be a lot of responsibility sometimes. I have to imagine that's a daunting task
It
sometimes.
can, and we think that's more important than the executor. It's more important than some of the other roles that people have, just
Yeah.
because if there is a family emergency or medical emergency, that person, again, is going to step into your life and take action for you, and you just hope they're gonna do the right things.
Yeah. Yeah.
So when we do have those discussions, we also have the agent sign an acknowledgement to that they will act in the principal's best interest,
Yeah.
and that they will act as the principal would if they know how the principal would. So that requires a discussion between the family members as well.
Yeah. Okay, so I want to switch topics just a little bit. Are there different considerations that you take into account if you have somebody who has an estate that spans multiple states? Is there, because I know you'll have to go through probate twice if you have, or I think something about if you have a property in another state, you have to go through probate twice.
Yeah, there's a mechanism in place for that.
Yeah.
So if someone has a will and they own a vacation home in
Yeah.
South Carolina,
Yeah.
typical example, or even Florida, we would likely need to open up an estate here and then also an estate in Florida to transfer that asset. That one of the two estates is the primary estate, and the other would be an ancillary estate. It's not as difficult, but it's still a burden.
Hmm.
And one way people will look at that is, and who's a good candidate to have a trust? Someone who owns property that's not within the Commonwealth of Pennsylvania. That way, if the out of state property is titled in the trust, then that property would not go through the probate process. That property would follow the language of the trust. So,
Okay.
trust ownership over that property would allow for future transfer to family members without the involvement of the probate court.
Yeah.
Yeah.
That's great. This one's a bit not silly, but it's I don't know how often you come across this. What should
We've heard just about everything. So,
Yeah.
okay.
What should I do if I anticipate disputes among my family members regarding my estate? Is that where the will comes into place? Is that, what happens
Yeah,
there?
that's an excellent question. And oftentimes what we see is that um, family members are more willing to argue with each other after mom and dad have both passed,
Right.
right? So, whatever politeness there might have been just goes out the window because there's no referee, there's no regulator of the family who kept everything together.
Yeah.
So, when we sense that might be a possibility, and we always ask, um, the clients don't always know that, but we can sometimes ascertain from the family situation and how often people get together and who keeps in touch with mom and things like that.
Yeah.
When we look at that family dynamic, we really want to say identification of the executor is very important.
Mhm.
Identification of how assets will be identified and what would be not necessarily an equal or an even distribution, but allocating assets in a fair and equitable way among family members. Sometimes that can be done without the will, and with through beneficiary designations is a good example. A trust can do the same thing, but depending upon maybe we have a client with an adult child that's lived with mom and dad to take care of them during a period of illness and has continued to reside in there. Oftentimes, it's the desire for mom and dad to have that child receive the house as part of their estate plan. Sometimes that doesn't sit so well with the other siblings. Um, you know, some I'm not going to say it's a rule, but the further away you live from mom and dad, the more likely you are to be upset by a lot of those
Yeah.
decisions.
Yep.
And so when we see that happen, it makes some sense to identify um, that discussion with mom and dad first, so we understand it. So when mom and dad pass, we have an understanding of how to handle that. But having handled a lot of disputes in the orphans court of Allegheny and Westmoreland counties, we really have some experience too as to how the courts will decide these issues. And using some of those thought processes and techniques will help us decide how do we eliminate the likelihood of that. So if we have we want to make sure we have validly executed documents, that there's not any undue influence by one of the children or other family members, that we end up with something that is a fair, looks like a fair result on paper. Doing those things and and understanding the family's assets and what are important. Oftentimes, we also see that people might fight over personal property. That would be any object that's in the house. It could be a valuable object, maybe collectibles or things with intrinsic value.
Mhm.
Coins and firearms oftentimes can also have sentimental value in a family. What we want to do is help our clients identify who should receive those things, right? And one technique would be to let's start uh, distributing those things during mom and dad's lifetime
Yeah.
so that everyone knows what's happened and it's not a fight for later. Oftentimes, too, that might reveal, right, which of the siblings is going to be more problematic.
Mm.
And that will also help mom and dad find the right avenue to make sure all the assets are distributed fairly.
Yeah. Yeah, absolutely. How often do you recommend people have their estate plan reviewed or that we're coming back to who's getting the guns? How
Right.
often do you think that is appropriate? And it may depend on the situation, I guess, but what's your kind of standard?
Yeah, we tell people about every 5 years
Okay.
if there's and why 5 years? It generally seems to be that, we get through an election cycle that way. We see that there also may be changes in the law. In addition to that timing element, we would ask our clients to consider whether there's been any death of a beneficiary, a disability of a beneficiary, a divorce of a beneficiary, or other changes in the family dynamic, such as someone who has been designated to have a role of executor. Are they able to still perform that? Maybe a younger child, a younger adult child, maybe gets married and moves away, and they may no longer be the best choice to be the executor. So we want to have that ongoing conversation as much as possible. But a 5 year window is a good one to just use as a rule of thumb.
Mhm.
Changes in the law sometimes can happen. without everyone knowing
Mm.
what has happened. The Pennsylvania power of attorney law changed in 2016 and in 2017. Different elements were added and different requirements were changed. So, particularly if your documents are older than that, we've been recommending that even if there's no change of people, we want to get those powers of attorney updated too.
Yeah, that's great. And I have to imagine if people have growing families, if they have new grandchildren that they want to leave something to that weren't in their will 5 years ago, now we have to do something for them to make sure they're taken care of too.
And that's right, and not everyone wants to provide directly for grandchildren, but they might wanna find a way to be remembered by the grandchildren,
Mm.
so we can find other ways to do that too with other assets or other accounts, identifying, what would be a good way for, the grandchildren to have a good and solid recollection of
Yeah.
generosity of, grandma and grandpa.
Yeah. I like the way you talk about that of there's obviously the legal side of estate planning, but then of course there's the human side of estate planning as well. So I like that you mentioned that maybe, the new grandbaby didn't get the Corvette, but maybe they will remember their grandparents for being charitable or for being, generous to the family, just being a nice person in general. So I like that a lot.
Yeah. And that's really part of the goal. We want people to understand what they're doing. We want people to know that their legacy is being honored
Mhm.
and that, the next generation should have an understanding of where this legacy came from.
Mhm.
After all, whatever inheritance is passed on is voluntary. It's
Yeah.
not a requirement, and particularly those that are younger that have received an inheritance, I think what would spark a note of gratitude, right? And those things, and so we also help our clients think of helping their grandchildren through making gifts. And just I need to tell you that in the year 2025, gifts can be made from one person to another up to $19,000
Mhm.
without filing a gift tax return.
Yep.
And there's no gift tax that is due on those amounts, but that is the annual exemption between two people. And when you factor in, two grandparents to one grandchild, they can pass on $38,000 to, and that's a nice gift
Yeah.
and something that those that have the ability and willingness to move their wealth to the next generation, it's a wonderful technique
Mhm.
and to help the grandchild with educational expenses or
Yeah.
other things.
And I think there's something with the super funding of a 529 plan that you can do as well, where you can do 5 times the annual limit to get all of that money out of your estate.
Yeah.
So yeah, I think there's that technique as
Yeah,
well.
and I think, if you wanna do that, you've gotta call YTS, but we stayed away from the money
Yeah,
itself.
yeah.
We just help people understand how to make those decisions and how to create the legal documents
Yeah.
along that.
Yeah, absolutely.
But that's one technique. Again, another would be, thinking about, you know, gifting personal property, and
Mm.
that's again, whether it's a piece of family, jewelry or memento, something else like that. Um, our clients want to feel that they're doing the right thing, and what we want to try to help them do is identify those opportunities um, to pass things on in a way that they know will be recognized and remembered
Yeah.
while they're here.
Yeah,
Yeah,
absolutely.
and that includes charitable bequests too. We haven't
Mhm.
talked about that,
Yeah.
but a lot of our clients are very charitably oriented, and so one thing to think about for your audience here is, which charities, if any, are really important to them and to
Yeah.
your family, to consider whether they should receive any portion of someone's hard-earned legacy.
Mhm. Yeah, absolutely. Um Do you have so we have clients that sometimes will, as we're thinking about estate planning now, of course, we are not estate planners. That's of course why we consult with you on our client situations. But there are times where we have clients that come in and we kind of project out their financial plan to show them what the rest of their life kind of looks like financially. And based on their living expenses, what I see is that they're never gonna run out of money, like, they're always gonna have something that they're gonna leave behind, and sometimes people see that and they say, "Oh, I don't wanna leave that much behind, I don't want my kids to have anything, I wanna just spend it all down from now until I pass away." Does that mean they don't need any estate planning, or what are the implications of
Well,
that?
that's an excellent point. So, if you've spent everything down successfully, then I'll tell you there won't be any inheritance tax.
Mhm.
That's one estate plan, if you will, not a written one, but the plan would be pass away without those funds in place. But um, our clients have a similar thought process, and that is if you see that you have a sufficient investment portfolio to support your lifestyle. Um, and then you have to think about what will happen next.
Mhm.
And that's a difficult decision and difficult thought process for many people because you're like, hey, I'm 65 years old. I just worked, just retired. I can see these projections that YTS gives me, or that, how am I going to, right, just turn that over to someone else? But thinking about it from with the idea of this mortality that we all have is how do you want to be remembered? How do you want to pass that on? And it might be that we find a way to support younger members of the family during difficult times, and the rest might be reserved for charity.
Mhm.
So there's different answers for different family members, different couples that we see. But that's a very common concern that we see as well, because you want to say, I don't want to die with all this money.
Yeah.
I don't want to save and keep saving. And when you reach a point, you say, okay, now it's time to maybe that second life of retirement. What are you going to do? Are you going to
Mhm.
travel more as
Yeah.
your spend rate might go up? But what are you saving for at that
Right.
point
Yeah.
too? Particularly if there's not an urgent need for other family members.
Yeah, absolutely. And I think back to the charitable conversation a little bit, if that's something that people want to do, or if they want to just get the money out of their estate, I think giving to charity is a really wonderful thing to do because you're giving back to the community, you're donating to a cause that you care about. And then something that we utilize a lot is taking advantage of qualified charitable distributions from somebody's IRA to get the money out of the estate, not pay income taxes on those distributions like you typically would for your RMDs, and then, of course, being charitably inclined and giving back to charity. So we also take some techniques into account for charitable gifting planning, that being one of the main ones, of course, but I know there are plenty of trust planning techniques that we
Yeah.
can use for charitable lead, charitable remainder trusts, and I don't think we need to get into all of that.
Right.
But I think that, yeah, giving to charity is a way to another way to be remembered.
Absolutely. And I think the entire concept of charitable giving um, means different things to different
Mhm.
people. Supporting your church, supporting your local charity, or maybe even supporting a school that you've gone to with financial means. It can mean more than just saying, I leave that to them in my will. The way to handle things is also to understand what has a tax deduction associated with it. Income tax of IRAs is something that is can get very
Mhm.
complicated, and the technique you identified is one that I think everyone should give some thought to if
Mhm.
they are charitably inclined. But understanding how the new rules under the Secure Act work with IRAs and other qualified plans, there's some opportunities, but also we have to look at what other beneficiaries, what will they do if they received your IRA,
Mhm.
and they need to withdraw those funds over a 10-year period,
Yep.
right? That's going to impact lives differently than
Mhm.
if you allowed them to receive income out of your family trust.
Yeah. Mm.
So again, just aligning your needs and desires for your future thought process and your legacy, aligning those assets with those decisions is a way to, I think, enhance an estate plan.
Mhm.
That is more than just filling out a form online and saying, this is what I want to have happen. Understanding those real emotional decisions too
Yeah.
is something that we try to work through our clients with.
Yeah, absolutely. Well, Jim, thank you so much for your time. This has been really, really insightful. So thank you so much for your expertise and for your trusted partnership as always. Jim, if anybody watching wants more information on you and your services, where can they find you?
I'll give you 2 hints. One is, the traditional telephone, that still works. Our telephone numbers at our main office is 724-733-8832. Our website also is a good mechanism to learn a little bit more about the things we've talked about today, also to receive some updates on if there's any changes, in the law. We tend to, make publications there in our blog, and that is, www.cbattorneys.com. C is in Creenan, B is in Baczkowski, and then the word attorneys. We try to leave educational information there, and if someone likes what they see, they can just send a message through our website, and we'll be in touch with them the same day.
That's wonderful. Yes, thank you so much again, Jim, for your time.
Thank you, Stephanie. Thanks for having me, and thank you to everyone at YTS for hosting.
Yeah, absolutely. If you enjoyed today's episode, give us a like, subscribe to Watch Your Assets on all social media platforms, and we will see you on the next one. The opinions voiced in this podcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision. Securities and advisory services offered through LPL Financial, a registered investment advisor, member FINRA/SIPC.